Child marriages in Africa often end a girl's education, exposes her to domestic violence and grave health risk from early childbearing and HIV, and traps her in poverty. In 2016, the Constitutional Court of Zimbabwe ruled that child marriages are unconstitutional. In the Constitutional Court's ruling, it focused primarily on the infringement of fundamental human rights created by child marriages. In this regard, Section 81 of 2 of the Constitution of Zimbabwe, Amendment number 20, Act 2013, states that the child's best interests are paramount in every matter concerning the child, and sexual exploitation or any form of abuse is intolerable. At present, Zimbabwe qualifies to be one of the countries in Africa that has a widespread presence of child marriages. According to the United Nations, approximately 1 in every 3 girls is married off at a tender age. Today, we are speaking about child marriages and in relation to a recent case which transpired in Mutare in Bocha, where a young girl aged 14 died while giving birth, and she was married off to a man way older than her. Hello viewers, welcome to Asondleni Abantwana, a program where we discuss all the fundamental issues that affect children, especially their well-being and rights. Right here in the studio, I have 2 gentlemen, Advocate Chitima and Mr. Newman Chiadzwa from the Royal Chiadzwa Trust. We are going to be discussing issues that affect children, especially child marriages. Gentlemen, welcome.
Thank you, Noxida. Thank you for having us.
The issue of child marriages is becoming a scare in the country, and so many kids are being sold off into marriage by parents and guidance. And it's so disheartening that we find that parents are actually partaking in selling off children. Mr. Chiadzwa, you are a leader in the Chiadzwa community. May you explain to us what your organization does, what your role in there is, and what the Royal Chiadzwa is?
Royal Chiadzwa Trust is a trust which was formed primarily to look at the welfare of the Chiadzwa people,
okay,
and also look at how children are being treated in our community. And at this stage, we are actually engaging experts in this area. We have UNATI, which has been coming to our place, wanted to know exactly how the children are being treated. With the recent case of Anna,
yes,
Machaya, zvakabata vanhu vakawanda, and madzishe ese vakaungana some few weeks ago kuti vaongorore nyaya iyoyi kuti why zvichidai. When we looked at this matter at the beginning, we thought pamwe vanhu vari kutonyeperwa nekuti ukafunga kuti mwana ane 14 anonzi aitiswe nhumbu, ozonzi abare futi pane vanhu vakuru vachizviona zvichiitika vachinyarara. It shows us kuti kutori nemhepo yakaipa iri kutenderera. Semadzishe totoona kuti imhepo iri kutenderera mumachechi imomo, kuti titi chechi inenge yapindwa nemweya upi kuti embrace such kind of behavior from its congregation, zviri kutotinetsa. Saka takadaidza mapato akati siyanei, so far tine mairi UNATI, DEMCO, ndo vari kumbotarisa dzimwe avo makesi manyowani, new cases which are actually emerging now in view of this and I think kuna vamwe vana vairi vari kutoziva izvozvizvi vakapuwawo nhumbu nevanhu vekuchechizve. And vana ivavo vabereki vacho vaitoramba kuti tiende kumapurisa, tiende kunovamanga. Saka tiri kuvimba kuti sezvo takatozozvia expose tikaenda kumapurisa tikanomangara, ndinofunga kuti pamwe mapurisa achaita mabasa avo. Tokumbirawo kuti dai kuti ruzivo rwemutemo rwekuti tinokwanisa kurupuwawo kuti zvikanga zvadai munodai, zvikanga zvadai munodai, nekuti vanhu they are getting away with it. Kuti aitisa mwana iyeye, aripa mwana iyeye, mwana iyeye otoita nhumbu, voenda kuvabereki vacho, vabereki vacho vanototi muroori mwana iyeye, vasina kana mupurisa ari kuzviziva, pasina madzishe ari kuzviziva. Saka ndiri kukurudzira madzishe ese anosangana nenyaya dzakadai kuti haisi nyaya yaishe yekuti mwana ane 14 aitiswe nhumbu voti vanokwanisa kuigarira pasi kuitaura. This is a police case. It should be reported to the police, and the police will take steps to get that person incarcerated. Saka ngoti ndo zviri kuita Royal Chiadzwa Trust takatoifomera kunyanya izvozvo nekuti vana havana anovadzidzisa kuti $5 haina zvainotenga, $2 haina zvainotenga. Saka vanosangana nevanhu vane mari dzakawanda, otopuwa mari kwakutokwidzwa motikari kwakutoenda. Nekuziva kwamunoita kuti kwaChiadzwa kune nyaya dzemadiamonds, kune nyaya dzema-illegal miners vanosvika ikoko vatinoti magweja today. They come there and take vana vadiki vachitovatakura kutoenda navo kwaMutare. And vabereki vacho vachiona zvakadaro vanotofara votozogumisira vatotengerwa magurosari nevanhu ivavavo. Saka isu zvinototirwadza semadzishe. Ingangondo nyaya yemushijiro ndio huru yatakamirira iyo.
That's quite sad to hear that we have such issues taking place in our rural communities, and especially where there's mining taking place. Kids are taken advantage of, they are exploited because the community thinks that there's mining which is involved. Advocate Chitima, what are the existing constitutional provisions and legal frameworks that allow protection and enforcement of child rights in Zimbabwe?
Thank you, Nokuthula. I think the starting point is the judgment which you referred to at the outset, the Constitutional Court judgment. It's Mudzure and another versus Minister of Justice, Legal and Parliamentary Affairs, and others. The Constitutional Court number 12 of 2015. So I'll take that as the starting point. So in this judgment, two minor children approached the Constitutional Court challenging the constitutional validity of particular provisions in the Marriage Act at that point, in particular Section 22 of the Marriage Act. They were also challenging the constitutional validity of the Customary Marriages Act, to say, in view of the new constitution and the provisions in the new constitution, these two pieces of legislation were now obsolete. They were now unconstitutional in terms of their provisions when viewed in relation to the new provisions of the constitution. So, in a detailed judgment, quite lengthy, quite articulate, the Constitutional Court came to the conclusion that both Section 22 of the Marriage Act was unconstitutional. So Section 22 of the Marriage Act at that point was to the effect that at the age of 16, a minor female may enter into a valid marriage, and at the age of 18, a young man, a boy, may enter into a valid marriage. So the court then took the provisions of Section 22 together with the new provisions of the constitution now. In particular, section 81 of the constitution.
Okay.
So section 81 of the constitution now defines a child to be a person who is below 18 years of age. And then section 78 subsection 2 of the constitution now says every person, in fact section 78 subsection 1, every person who has attained 18 years has the right to found a family. So these provisions taken together, effectively they now mean that a person can only enter into a valid marriage at the age of 18 years, which is a departure from the old section 22 of the Marriage Act, which allowed girls aged 16 to enter into a valid marriage. So now, in view of that judgment of the Constitutional Court, there is now an obligation on the legislature, because the parliament is the lawmaking arm of government. The courts are just there to interpret the law, to say, is this provision constitutional, is it not? But after they declare that it is unconstitutional, the ball now is in the court of the parliament, the legislature, to then canvass the people to amend the laws accordingly. So at present, the Marriage Act is supposed to be amended. I understand it is at the second reading stage. So these are formalities in Parliament through which this Act should be amended to reflect the new position now, which is laid down in the Constitution to say below 18 years, a marriage is not valid. So the judges, the whole panel of the Constitutional Court in this Mutsuri judgment of 2015, just to emphasize the importance with which they view this matter, their desire to put an end to child marriages. They went on to say in their judgment that even when a child is now pregnant below 18, it does not mean that they automatically become an adult. It does not validate the marriage. They still remain a child. So the court went on to say the parents may want the husbands or the male counterparts just to acknowledge that they are the father of the child, but not to say that they are going to marry the young woman.
Okay, that's quite intriguing, and to note that our parliament is actually setting bills that are trying to protect minors, especially in the issues of marriages. Chief, I'll call you Chief Chiadzo because you are representing the chief himself. What advice would you want to give to other traditional leaders, especially in these issues that are actually affecting the young girls, the girl child being married off at such tender ages? What would you want to say to your fellow traditional leaders in various communities?
Yes, we can only give advice to other traditional leaders when we know what the actual law says. I've just heard the advocate talking about this constitutional judgment from the Supreme Court. Is it possible that I can ask you the
yes, please.
Advocate the question?
Yes, please.
That they are talking of marriage. What about sexual intercourse with that child? Is it a criminal offense if the child is 16, 17? Does it remain a criminal offense if they are not marrying, or because I failed to understand when you were trying to give us this side of the story.
The context. Okay, thank you, Chief Charles. So I began with the constitutional provisions, because those ones are specific on child marriages, but there are also provisions in the law which deal with sexual intercourse or sexual relations with minor children. So, in the case of Anna Machai, the man, the accused person, has been arrested for contravening Section 70 of the Criminal Law Code. So what Section 70 does is to outlaw sexual relations with girls who are below 16 years of age. So the Criminal Law Code, which is a summation of all the crimes in the country, actually criminalizes sexual relations between an adult man and a girl who is below 12 years of age. So the offense is actually defined as having sexual intercourse or relations with a young person. And then if we go to Section 64 of the same Criminal Law Code, this one in strict terms prohibits sexual relations involving young women of 12 years, in fact 14 years and below. So in that instance, the offense becomes rape, as opposed to simply sexual relations with a young person. So the law is clear. It prohibits all forms of sexual relations with young females of below 16 and below. So I think it is for the law enforcement part, for the community, for the parents, even for organizations like yourself, to now conscientize the people, to conscientize communities that these laws actually exist. So,
okay. Yes, advocate. It becomes still it's a bit hazy and clear. If you are allowed to have intercourse with a girl below 18, then culturally, if you are allowed to have intercourse, it's like you're allowed to marry according to culture, because you can't culturally you can't have intercourse with a woman if you don't marry that woman.
True.
So how are we going to define that? How are we going to teach other traditional leaders or communities? Are we going to say don't have intercourse with the children below 18, or don't marry? What are we going to say to them?
Well, it's getting heated here. You know, we have cultural norms that actually are defending the girls, and he's actually mentioning it here. And then we also have the law, and it categorizes how a person is supposed to be given their judgment when they have sexual intercourse with a child. While we take our breather in here, take yours as well. We'll be right back after this short break. Thank you so much. Welcome back to Asondleni Abantwana. It's so heated in here in the studio where we're discussing the issues of child marriages. Previously, we were being actually informed by our advocate Chitima on the constitutional provisions which are set place to actually protect the children against child marriages and all forms of abuse. And also we heard from Chief Chiadzo on the measures that they have taken as the Royal Chiadzo Trust in curbing child marriages in their community. Chief Chiadzo, you had a burning question on how the Constitutional Court, the bills, they actually help in enforcing laws that govern children, and at the same time they seem to contradict with the traditional values that you have as traditional leaders in the various communities. May you continue with that, sir?
Yes, I was just asking the advocate how we are going to teach or conscientize other traditional leaders on this issue of this constitutional provision that you can only have intercourse with the child, but you can't bear the child. Then culturally it is clashing, because you are not allowed to marry, but you are allowed sexual intercourse with the child. So how are we going to live with something hanging like that? How do we teach the community to protect the children?
Yes, Advocate, what do you have to say about this?
I think I'll start by agreeing with the observation by the chief. It's a actually appropriate observation that there appears to be a clash between the law as written down in the law books and culture on the other end. Was taking the provisions in the criminal law code, section 70 and section 64, taken together. What is created is a suggestion that you may have intercourse with the minor who is 16 and above, but you can only then marry that minor once they attain 18 years. So I think that's where the chief is querying the inconsistency, the apparent inconsistency within the law. So indeed there's that inconsistency. Was from a cultural point of view, once a child begins to engage in sexual activity, for the protection of that child, for the protection of even society, one assumes that they should then be in a marriage setup. You cannot be promoting promiscuity, as it were, extramarital activities, to say you can engage in extramarital activities, but you are not going to be married up until you get to 18. So the risk is that once they engage in sexual activity, there's pregnancy, automatically they are driving towards marriage. So I think to try and reconcile those seemingly contradictory positions, that is where people are saying there is need for alignment of the Constitution and these other laws. Because the Constitution is now clear to say sexual activity, interpreting the Constitution, section 78 of the Constitution and section 81, interpreting them broadly, purposively. What those provisions mean is that sexual activity should begin at 18, because that is when a person is now an adult. Below 18, they are still a minor, they are still a child. So I think to cure that inconsistency, there's need now to amend those provisions in the criminal law code to make them match up with what is in the Constitution. Instead of talking of 16 years now, we bring it to 18 years, so that there is criminal penalties for sexual intercourse with children below 18. And then if it is 14 years or 12, it's even serious, it's worse, it's rape. So, but I think it has to go back to the community through Parliament to say, is this what we want? Do we want to raise the age of consent to sexual activity from 16 to 18? Because without the people through Parliament agreeing to this, then it doesn't reflect the will of the majority. So it has to go through the referendum, Parliament, and so forth. But I think it is an important observation by the chief. In fact, it is one of the criticisms being leveled against section 64 and section 70 of the criminal law code, to say it appears the crime is only committed, it refers to extramarital sexual activity, and yet you can only be married according to the Constitution at 18. So critics are saying, why not elevate and the age of consent in the criminal law code to 18, so that there is harmony between the Constitution and the criminal law statutes.
Okay,
Thank you very much.
that's quite interesting. Chief Chiadzwa, do you as traditional leaders have time to rebuke each other as leaders in the community when such issues actually come in? or each community actually deals with its own issues?
No, we have time to sit together and put all our cases together and analyze them as community together. We don't rebuke
Okay. So
unless it is actually related to this child marriage, which we are saying no.
no, that's great. We are going to take another a break as we try and synthesize on what has been said here. The two gentlemen are actually relating out how child marriages are affecting children, how they're affecting children in their communities, as we have a guest representing the Chiazo community, and Advocate Chitima as well, who's giving us the legal bindings on how one has to be prosecuted, how a child is actually protected through the constitutional provisions which have been set place. We are going to be back with yet another segment from this program. Welcome to the last and final segment of our show here at Asondleni Abantwana. Before the break, you heard from the two gentlemen how child marriages are affecting children, especially in the rural communities, where a child is sold off to marry a man who is twice or three times their age, and in most instances, in relation to the issue of the late Anna Machaya, children die, especially during childbirth. And it's so disheartening that we as a country have allowed this to carry on and happen for decades. But it's quite a relief that our government and the judiciary has actually put in a set of laws that are actually protecting children from child marriages. Advocate Chitima, please explain to us the types of marriages that are actually there in the country that are recognized by the law of Zimbabwe.
Okay, thank you, Noktula. So, really, I would say there are two regimes of marriage in the country. The first one is the civil marriage under the Marriage Act. So this is like the modern sense of marriage, where people go before a marriage officer, be it a magistrate or a pastor at church, and they exchange their marriage vows and they sign the marriage certificate. So this is like the preferred, maybe by women or by progressive people, the preferred form of marriage in the country, because it affords protection, maybe in the case of divorce, death, inheritance to children born of the marriage. So this is the civil marriage in terms of section 511, the Marriage Act, previously chapter 37. And then secondly, there's the customary marriage. This is the marriage in terms of the Customary Marriages Act. So under this regime of marriage, that is where people go and pay lobola to their in-laws, and there are no formalities in terms of signing any marriage certificate. It's customary, as it were. That's why it is called a customary marriage. Yes. So basically there are these two. And then there are instances where maybe for inheritance purposes, people were cohabiting, people were living together as woman and a man, but not having followed through the marriage rights. And then to protect women, they are what are known as putative marriages.
Okay.
Yes. So putative marriages, you maybe the husband has passed away, the woman wants to inherit, or there are issues of maintenance or succession and so forth. The courts will deem that there was a marriage for the benefit of the wife. So others may not want to consider it a marriage, others may want to consider it a marriage.
Oh, okay.
I think it is one of the things which are coming up in the proposed marriage bill and the amendment to the Marriage Act,
Okay.
to also try and recognize these marriages.
Oh, all right.
Yes.
So the marriage bill, the amendment, which stage is it at now? Because so much has been said about it. There have been public hearings about the marriage bill, which have taken place across the country. So where are we now with this marriage bill, and what is the community saying about it? What are people saying about it? Are they coming up? Are they giving the parliament suggestions on how it should be said? What's happening? I feel people need to know and understand what's really happening around this new marriage bill which has been set place.
Indeed. From my recent reading of the process, it is at the second reading stage.
Okay.
So in Parliament. So the second reading it's called second reading, but really there's no reading going on. It's parliamentarians voting for and against the proposed bill, making comments, suggestions. So at present, I understand the bill is with the minister. He's considering input from the Senate. So after he considers input from the Senate, it moves on to the House of Assembly, the Parliament proper, as it were, for the second reading stage. After the second reading, it goes for the third reading, and then other processes until it is enacted into an act of Parliament. So I think there's a delay in the process. I think Parliament's lawmaking schedule is a bit congested. There are a lot of bills which Parliament is having to pass so that they align with the Constitution. So I think there's that delay. And also the last time, the sticky issue was one on lobola, whether or not to do away with the concept of lobola in our marriage regimes. So I think that was the sticky point, even in Parliament itself, even in Senate itself. There's no consensus among the parliamentarians and the senators.
Okay, so in that line of thought, advocate, as a nation, should we revisit the issue of lobola?
I think that is a contentious topic, because, like, from a cultural point of view, people would want to retain lobola, because I think from a customary point of view, lobola it signifies that a man has paid, has formalized the process. So to do away with lobola, it may be contentious. But on the other end, in terms of the general law, in terms of the Marriage Act under Chapter 5.11, both parties, the man and the woman, once they attain 18 years, they are adults. They can enter into a marriage without the need for consent from parents. So they may decide they just want to sign their marriage certificate without the need for lobola, and legally they are married.
Oh, all right. But then what strategies can be adopted to empower women and children against violence?
Indeed, I think that is important. I think in response to that, I don't think there's a one-size-fits-all approach to that.
Okay.
I think it's really all hands on deck. All people involved in law enforcement, not necessarily just the police, but even the communities themselves, Parliament. Because I believe already there are in place laws which are there, which protect women from abuse, from domestic violence. They may approach the courts for peace orders, protection orders, and so forth. But the question is, do they know that there are those remedies available to them? So I think that is where organizations like yourself come in, to conscientize the communities, to conscientize the people, even for the police to be vigilant, members of the public to report on such issues. Like we've seen now with the case of Anna Machai, even the importance of social media. Everyone is almost aware of this case because of the role of social media. Even traditional media platforms like print and all those forms of media. It's really making people aware, conscientizing. And also I think reviewing our penalties in terms of the criminal statutes, making the penalties more stiff was many times people, main abusers are arrested for infractions, but maybe a week or two later, you see them walking the streets, maybe just having been warned or fined or sentenced to community service. So I think there's need for stiffer penalties, because if a would-be offender knows that they are going to face a serious time in incarceration, they will reconsider before engaging on such.
Okay, I have this one question for you, advocate. Why, in your own opinion, why do you think the government has allowed the gathering of the Johane Maranga sect during this COVID-19 lockdown? You know, there hasn't been any social gatherings, but there have been. Why do you think the government has allowed that?
I think to say government is made up of various arms.
Yes.
Government is broad.
Yes.
So
Government and the law enforcers as well. Yes.
So there's the judiciary, there's the parliament, there's the executive, the law enforcement, the police. So I think the back lies with the police. Yes. Because the lawmaker made it clear that there's not supposed to be a gathering of 50 plus people during the lockdown period. So it is now for the police to enforce, to say you should not exceed the prescribed number of people in this gathering. So I think this case was made reference to in social media, in newspapers, even on the radio. So it was really for the police to simply do their job.
Well, as a way of wrapping up, advocate, what are your recommendations to the community, the traditional leaders, the civic organizations on how to handle these issues, especially in relation to Anna Machaya, you know, what she went through as a child? What recommendations do you have to these stakeholders as a way to actually help in fighting child marriages in the country, as a way to cap child marriages in the country? What do you have to say?
I think in summary, really, it takes the whole village to end this scourge of child marriages, early marriages, which sometimes result in death, as in this unfortunate case. So really, it takes everyone to come on board, to put our hands together, to collaborate our efforts, really, because separately there's enough everywhere. Like I indicated earlier, the Constitutional Court, as far back as 2015, in a detailed judgment, dealt with all these issues. So really, if people had paid attention back then, or even from the 5 years from 2015 up to now in about 2021, if people had paid attention to that judgment and what is written in the judgment, if Parliament had speeded up the aligning of the laws with the Constitution, if civil society had conscientized the people, you see, I do not think we would have come to this unfortunate point. Now you see, now everyone is rallying together, seeing that this is unacceptable in the 21st century. But I think as a country, as communities, people were too casual with this issue. So I think it's unfortunate, but it is a timely reminder that we need to come together to deal with this problem.
Well, viewers, you have had it all. My question now is, did it have to take the death of a young girl, Anna Machaya, for the nation to actually realize that child marriages is a no-no? Child marriages is very pathetic. Child marriages should not be tolerated in our country. You have had the views from our two guests who have actually spoke out how child marriages affect children and how the law is trying to help curb child marriages in the country. Here in this program, Asondleni Abantwana, Advocate Chitimba, it has been wonderful to have you here. We hope that you will continue as a law enforcer in our country to help fighting for the rights of children, especially child marriages that have become a scare here in Zimbabwe. Thank you so much for taking your time to be here in our program, Asondleni Abantwana. Babukeli, it has been good having you here. Hope to see you in our next episode. Lisale kuhle. Take care.